Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya. In today's insightful episode of Polity Primer, we are going to understand and discuss yet another important constitutional amendment. The title of our today's discussion is the 26th Constitutional Amendment Act. In this discussion, we are firstly going to study about what are Privy Purses. Then we are also going to study about the 26th Constitutional Amendment. Then we are also going to examine its historical background. Then we are also going to study the key provisions that have been inserted in the Indian Constitution through this amendment. And lastly, we will be seeing some of the important questions for your preliminary examination. So if I talk about the 26th Constitutional Amendment Act, so before we understand it, it is very important for us to understand what are Privy Purses. So this term Privy Purses is very useful for us to understand before we actually understand the 26th Constitutional Amendment. So basically on the promulgation of the Indian Independence Act 1947, the princely states adjoining the Dominion of India merged with the Dominion of India. So as you all are aware that there are 555 princely states. So when we got our independence, we asked them to sign the instrument of accession, and after the enactment of the Constitution of India, they were finally integrated with the Dominion of India. So the instruments of merger or accession provided for the integration of the states and guaranteed to the rulers of the princely states the privy purse, succession according to law and custom to the gaddi of the state, and the personal rights, privileges, dignities and titles. So basically, if I explain to you this privy purse in very simple terms, it was a special grant in monetary terms to the erstwhile rulers of princely states, and it also included various other privileges. Okay, so various grants were given to them after the enactment of the Constitution of India when they finally merged with the Dominion of India, and they also enjoyed certain privileges. Moving forward, special provisions were enacted in the Constitution regarding the Privy Purses and the rights and the privileges of the erstwhile rulers. So Privy Purse was an important part of the right of the erstwhile rulers. Okay, they were given some of the important monetary grants and privileges because they agreed to finally merge with the Dominion of India. They agreed to finally integrate with the Dominion of India, and this was their condition for integration. Moving forward, by Article 291, the sum guaranteed by the Dominion of India to any ruler as Privy Purse under any covenant or agreement was to be charged and paid out of the Consolidated Fund of India. That means, as per Article 291, Privy Purse was a charged expenditure. Privy Purse was a charged expenditure. On the Consolidated Fund of India. That means it could not be put to voting in the Parliament. So there are some charged expenditure on the Consolidated Fund of India, such as examples are salary and allowances of the President of India, Vice President of India, salary of the Supreme Court judges, High Court judges, etc. All of these are charged and expenditure on the Consolidated Fund of India, and definitely Parliament does not have a right to vote upon them. Okay, and sums so paid were to be exempt from all taxes on income. So basically it was a tax-free income. Privy Purse is a tax-free income that was given to the erstwhile rulers of the princely states. So by Article 362, the Parliament, the state legislatures and the executive of the Union and the states were enjoined to have due regard to the guarantees and assurances under the covenants and agreements between the governments of Dominion of India and the heads of the former Indian states, because they had this condition that yes, you will have to give us special rights, privileges for integrating into the Dominion of India. So basically the government of India as well as the state legislatures were bound to fulfill their obligations under the instrument of accession. Moving forward, by Article 366, Clause 22, a ruler was defined when our Indian Constitution was enacted. Article 363 excluded the jurisdiction of the Supreme Court and all other courts in respect of any dispute arising out of any provision of a treaty, agreement, covenant, etc. or in any dispute in respect of any right occurring under or any liability or obligation arising out of any of the provisions of the Constitution relating to any such treaty, agreement, covenant, etc. So basically these instruments of accession or instruments of merger were outside the purview of judicial review by the courts in India. Judicial review of these covenants or treaties or agreements were not allowed by the virtue of Article 363. Now, let us discuss what is the 26th Constitutional Amendment Act. So basically the 26th Constitutional Amendment Act was brought in response to the Privy Purses case, and this is a very landmark judgment of the Honorable Supreme Court of India at that point of time, because as I have explained in my previous sessions as well, there were two legal questions that were the focal point of tussle between the Government of India and the Honorable Supreme Court of India, and these questions were firstly whether DPSP could override fundamental rights, and the second question was whether a Constitutional Amendment Act can be considered as a law, for the purposes of Article 13 Clause 2. For the purpose of Article 13 Clause 2. So basically these two questions, legal questions, were the focal point of tussle between the Government of India and the Honorable Supreme Court of India. Though there were talks in the Supreme Court of India in various cases to harmonize the fundamental rights with the directive principles of state policy, because as per Article 37 they were non-justiciable in nature. But the government at that point of time had a very socialistic bent of mind. So this formed a point of tussle between the Supreme Court and the Government of India at that point of time. Okay, and the Privy Purses case is the H.H. Maharajadhiraj Madhav Rao Jivaji Rao Sindhya Bahadur of Gwalior and others versus Union of India and another. This judgment is famously known as the Privy Purses case. So through the 26th Constitutional Amendment Act, Articles 291 and 362 were omitted from the Indian Constitution, stripping former princely state rulers of Privy Purses and other privileges. So basically through the 26th Constitutional Amendment Act, we abolished the Privy Purse. The Government of India at that point of time abolished the Privy Purses. Now let us examine what exactly was the historical background behind the same, and why did the government abolish the Privy Purse through the 26th Constitutional Amendment Act. So basically the 24th Constitutional Amendment Bill was enacted by the Parliament. So what happened? This bill was enacted, it was passed in the Lok Sabha, but the government at that point did not have the majority in the Rajya Sabha. So the bill failed in the Rajya Sabha. And you know, for a constitutional amendment to become an act has to be passed by both the houses of the Parliament. So immediately after this, 24th Constitutional Amendment Bill failed in the Rajya Sabha, okay, because it was related to the abolishment of the Privy Purses. So basically what did this presidential order do? It changed the definition of ruler. Under Article 366 Clause 22. Okay, so by utilizing the power, the president changed the definition of the rulers in the Article 366 clause 22, and all of the rulers were made out of the definition that so that the Privy Purse could be abolished. So basically the whole definition of ruler at that point of time was changed. So the H.H. Maharaja Dhiraj Madhavrao Jivaji Rao Sindhia Bahadur of Gwalior and others versus Union of India and another challenged this presidential order, which basically changed the definitions of rulers under Article 32 of our Indian Constitution. They said that it is a violation of our fundamental right, not only the fundamental right to property but also receiving those privy purses, because it was a special right that had been guaranteed to them by the Constitution of India. So basically in this judgment, the presidential order under Article 366 clause 22 was challenged. It was ruled by the Supreme Court that the presidential order of September 6, 1970 was unconstitutional because it violated the court's rules under Articles 362, 291 and Article 366 clause 22 of our Indian Constitution. So basically in this case the Supreme Court ruled in the favor of the erstwhile rulers of the princely states and said that no, they really have some important and precious rights, and the government is bound to fulfill its obligation under the instruments of accession. Now let us understand what are the key provisions of the 26th Constitutional Amendment Act and the changes it made in our Indian Constitution. So basically Article 366 was amended. So the definition of the ruler was changed. So we know that in 1971 the general elections took place and the Indira Gandhi government received a massive majority. So she started bringing all of these amendments to bring socialism in India, to fulfill that yes, the directive principles of state policy have a overriding effect over the fundamental right if they are for public purposes, if we are making laws for public purposes. So basically Article 366 was amended to change the definition of the ruler. So the amendment to Article 366 was concerned with the substitution of clause 22, which defined ruler in Article 366 with a more clear definition of this word ruler. Okay, so under this amendment, ruler refers to any prince, chief or other person acknowledged by the president as the ruler of an Indian state prior to the initiation of the Indian Constitution, as well as any person acknowledged by the president as the ruler's successor at that point of time. That means after the enactment of Indian Constitution, we are not going to recognize you as a ruler. Whatever happened before the enactment of the Indian Constitution. So basically it changed the definition of the word ruler. Moving forward, the 26th Amendment to the Indian Constitution also added Article 363 Clause A to the Constitution, which stripped any princely state ruler of their title and privileges, and this includes the Privy Purses. This includes the Privy Purses. And that is why we say that yes, this amendment abolished the Privy Purses in India. So basically the 26th Amendment of Indian Constitution of 1971 completely removed Article 291 and Article 362, which talked about these special grants to the erstwhile rulers of the Indian state. Now what happened after this? The 29th Constitutional Amendment Act was also enacted, and basically it placed the Kerala Land Reform Act into the 9th schedule. Okay, so this 24th, 25th, 26th and the 29th Constitutional Amendment Acts were finally challenged in the case of Keshwanand Bharti. Keshwanand Bharti versus the state of Kerala. So who was Keshwanand Bharti? He was a manager of a mutt, okay. and he challenged, after his managerial rights was snatched, he challenged all of these amendments. Basically, the case was related to the 29th Constitutional Amendment Act, but he challenged all of these amendments, that is the 24th, 25th, 26th and the 29th Constitutional Amendment before the Honorable Supreme Court of India. The Supreme Court also made its stance clear that yes, Parliament has the power to amend the Constitution of India, because if we say that the fundamental rights cannot be amended, that means we'll not be able to work for the people of India, okay? Because our constitution is not a static document. It is a very dynamic document that has the property to adapt itself as per the changing needs of the society. So the Supreme Court acknowledged that yes, the Parliament has the amending power over the constitution, but it cannot amend the basic structure of our Indian constitution. Sorry. Basic structure of our Indian constitution. And this is how finally the basic structure doctrine was evolved in the Keshwanan Bharti case. That means the Parliament has the amending power, but it cannot amend the basic structure of our Indian constitution. With this, we come to a conclusion of our today's discussion. We have seen the 26th Constitutional Amendment Act. We have also examined its historical background. We have also seen what were the Privy Purse case. We have also seen what are Privy Purses, and we have also seen the key provisions that have been inserted in our Indian Constitution through the 26th Constitutional Amendment Act. Now let us discuss the previous practice question which I asked you in my previous session, because I said that I will be revealing the true answer or the correct answer in this session. So the question was, which article is inserted in the Indian Constitution by the 25th Constitutional Amendment Act? Your options were, option A was Article 31A, option B was Article 31B, option C was Article 31C, and option D is none of the above. So your correct answer will be option C, Article 31 Clause C was added to the Indian Constitution by the 25th Constitutional Amendment Act. Now let us discuss the practice questions from today's session. So the question is, Article 368 provides for the procedure for amendment of the Constitution. About amendment, consider the following. Statement number 1, all amendments to the Constitution are initiated only in the Parliament. Statement number 2, after the passage of the amendment bill in the Parliament and in some cases in state legislatures, the referendum is required for ratification of the amendment. Which of the above statements are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is none of the above. So your correct answer is going to be option A, 1 only, that all amendments to the Constitution are brought or initiated only in the Parliament. So this is the correct answer. Now let us discuss the last question of our today's discussion. The question is, the 26th Constitutional Amendment Act is related to option A or option 1, abolition of Privy Purses, option 2, bank nationalization, option C, basic structure doctrine, and option 4, none of the above. So this answer will be given by you to me in the comment box below, and I'll reveal the correct answer in the next session. I hope this session was insightful for you. If you have any feedback regarding this session, kindly drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such updates. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.